Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in our cause number CV220478, Arapaho LLC versus Searle. Counsel, we have read the briefs. We've discussed this case in argument today. Please keep that in mind when you make your argument. Both sides have 20 minutes to make their presentation. Appellants are responsible for maintaining any time they wish to have in rebuttal. Please, when you step to the podium, if you would announce who you represent, your name and who you represent. And with that, Mr. Jacobs.
Thank you, Your Honors. Good morning, and may it please the Court. Andrew Jacobs with Corey Braddock for the defendant below, appellant in this court, Christine Searle. Postage is getting more expensive, but it's still a lot cheaper than litigating an appeal for failure to put one postage stamp on one envelope that would have avoided this entire case by providing the best notice required, as the Ruiz case from this court indicated should have occurred, but did not occur here. Ruiz is a case that provides the governing standard. The Superior Court did not discuss the concept of the best notice practicable under the circumstances. That's the legal standard from this court, and the court must...
Mr. Jacobs, it seems to me the best notice practical under the circumstances would be the statutory designation of where the person has their mailing address, right?
No, Rule 55 indicates that the best notice practicable would be where a person is known by them to be, and they had never successfully reached Ms. Searle at the Ash address. They had successfully reached her at a horse stable once, 2 weeks earlier. They had never reached her directly at the Ash address. The Superior Court treats that as having been accomplished, which is just incorrect.
I thought they had served her at that address previously.
I'm sorry, Judge?
I thought they had served her previously in that address.
They had sent her materials. What ends up being cited when you pull the strand up, it's at App 4 in the court's decision, it says, well, we sent her things that the court says got to her at that address. And when you pull up the reference in the appendix, which is appendix page, I'll get the page, appendix page 81, that's a receipt that someone signed. But that's not what Rule 55 talks about. It's not that someone signs, it's that you find her. That's the whole point of Ruiz. You got to find her, not just find someone who has an illegible scrawl. The son is not her. That's due process.
But she had no responsibility to change her mailing address with the two governmental agencies. Well,
Judge McMurdy, I think it's really more about serving the person than serving property. I mean, property is property and people are people. Rule 55 is about finding the person. They keep making this point that, well, she owns that, and the county has that on record. Well, what if you didn't update your address? Does due process mean that you can be defaulted?
Well, then shame on her. She should have updated her address. And when you mail it to the address, you're intending that the person is going to receive it.
Well, it's shame on her, but not shame on her that you lose your house if you didn't update your address with the county, for example. That's why the point is to find her under Rule 55. The statute's not set up to be like something you register with the state as your service address. It's not like serving a corporation. That's not the plain purpose of information you throw out to the Maricopa County Superior Court, or excuse me, the Maricopa County Assessor. That's not what it's for. If they had mailed her there and she got the mail, we'd be dead. That didn't happen. The court can't point to that. At page 4 again in the ruling, it says, well, she got the stuff. But again, if you pull the thread up and you go to App 81, you have an illegible receipt, and really it says someone got it. Well, someone getting it doesn't suffice under Rule 55. You got to find her, not her son. That doesn't count. Okay. So there are 3 methods of service that are indicated here, and the court relied on 2 as, quote, whereabouts. If we look at that...
Counsel, you said there's 3 methods. How do we know there weren't more?
There could have been more, Judge. There could have possibly been more.
In a particular situation, let's say in today's world, you go to Google and you pull up, and it says, these have all kinds of sites about people locator or whatever, right. And it says 15 possible hits. Which of those are the best practicable?
And that would make a lousy rule for the reason that your question really calls out, Judge. So I agree with you. But Rule 55 is part of a set of rules that is designed specifically, and especially in Arizona, to avoid unnecessary defaults, to give you a chance to unring the bell. So it's constrained. The reason that that hypothetical doesn't answer this case, Judge, is because here you don't have 15, you have 1. They did a search, and they sent someone to camp out where she lives.
In the prior litigation.
5 months earlier. Okay. The same people, 5 months earlier, trying to get the same house. I mean,
And they didn't find anybody there.
They didn't succeed in serving her. That doesn't mean that their notion of whether she might be found there went from 100 to 0. That's their premise.
Was
That
there
doesn't really
any
make sense.
indication, anything in the record indicates that the process server believed that she lived there?
The use of the word home 5 separate times on app 65, we didn't put there. I didn't put that there. They put that there. The word home is 5 times on that page. It's her home address, couldn't find her at the home, it's the home. I mean, I don't know what more I would have to show that they subjectively believed she was there. And the standard that they supply, Judge, is a very low standard. Their notion in their brief of no is this perceived, recognized, or understood. If that's the standard I've got to get to, and their process server 5 times says home, and they stay there for 5 days and 11 days, how is it that 5 months later, magically, they don't have to do that again? That's just really mystifying.
Mr. Jacobs,
stable is okay. Sorry, Judge.
what evidence is there in the record that in September of 2021, that Ms. Searle was actually living at the Jackson address?
Her attestation that she was.
Yeah, but her attestation, I looked at it, it said in March of 2022, I live at that address. It didn't say where she lived 5 months prior in September.
Well, and I think, honestly, Judge Catlett, I mean, to the point of your question, no one raised that temporal distinction. She just said, that's where I live, and that's where they thought she lived, and that's the only evidence.
Yeah, but don't you have the burden in trying to set aside the default judgment to say, first, that her whereabouts on a particular date were X, and then the second step is, and they knew about it. So I'm trying to figure out what evidence there was to satisfy step 1.
Well, I think the burden is to show that under Rule 55, they had knowledge, meaning, their words, perceived, recognized, or understood. If they perceived, recognized, or understood at that time that she was there, then they would find that.
But if they had knowledge of somewhere she didn't actually live, or there's no evidence in the record that they had knowledge that she actually lived at the address, I don't understand how their knowledge is relevant.
Their knowledge is relevant because the face of Rule 55 makes it relevant. It makes it the governing, constraining concept. That's why, to Judge Brown's question, it isn't 15 hits on Google, but if there's one that you think is the one, as evidenced by you sending someone out there for 2 weeks, that's a degree of perception, recognition, or understanding that rings the bell under Rule 55.
And I think Judge Brown's question sort of points at the issue of Ruiz says best notice practicable, but Rule 55 says known whereabouts, and I'm not sure that those two are necessarily consistent, so I was hoping to get your view on how those two line up.
Sure, and again, I mean, I would start from the premise, because it's this court's decision, it's the only published Arizona decision about whereabouts in Rule 55, I'm going to start from the premise that Ruiz guides us on whereabouts. So I see those as being fairly consistent from my position, and I think that the degree of knowledge is not perfect. Law does not require perfect knowledge. That's not what the case law does. And also, there's an inconsistency in the idea of, well, where was she on that exact day? I mean, where was she on the exact day at the horse stable? But we're supposed to treat that as good enough. I mean, if we apply consistent reasoning and we don't hold her to different proofs and logics than them, then, well, what's the proof she was at the horse stable on that exact day? But they mail it to the horse stable, right? Because they have a notion that she might be found there. And that's
Well, they served her there.
Well, they had served her at a public place, right?
Right, so they'd served her there. So just out of an abundance of caution, they also sent it there. I'm just curious, go back to the knowledge that follows up with what Judge Catlett asked.
Right.
Sure, they thought she might be living at that Tucson address, but she was never found there.
Well,
And they went there 5 days, and they still didn't find her there. So do they have to keep going to that address? Even though, and again, what evidence is there that she actually lived there when they were mailed it?
I feel the panel not being persuaded, but at the same time, do they have to keep going there? That's so the point of it, Judge McMurdy. What's the burden? The burden is one stamp. Do they have to keep putting a 50-cent stamp on an envelope? I mean, what's the burden in the law to do that? And to the point of the question that you're both raising, at least as I perceive it, if I'm not answering it, I apologize. In Ruiz, they talk about whereabouts as, quote, where they can be found or located, not an area or locale where they might possibly be found. Where is where you can be found or located Or instead, bad might possibly be found. A horse stable, that's where you might possibly be found. Where can you be located? Your home. And they say, oh, well, she doesn't own it. Well, so what? This isn't about property. Everybody keeps making this about property. People who live in apartments don't own it. That has nothing to do with service or fundamental fairness, number one. Number two, where she can be found, I mean, okay, so she has to pay taxes on the thing at Ash. That's not a place where she can be found. They sent a process server there 5 times. They think she can be found there. The fact that they didn't succeed absolves them for all time from understanding that to be the one place she lives. There's no theory in this record other than mine of where she lives. I mean, to the point of your prior question, Judge Catlett, well, what's the evidence she lived at that exact address that exact day? There's no evidence in the record other than she lives where she lives. I mean, I don't know why.
Not just that exact day, but just like something beyond, this is my address. I mean, it doesn't go back in time at all. There's no utility record, there's no evidence of, I mean, a Google screenshot or something saying, this is my home, I lived here for 5 years, 1 year, 6 months. If she didn't, then that's telling to me. Why am I off base there?
Well, they researched it enough to know that someone else has owned it since 2014. So they know more than they're letting on. They say, well, since 2014, someone else has owned the property. And they think she lives there and they send someone there. But, you know, the thing that's sort of weird about this is she has an attestation that she lives to a place that they sent someone on the theory that she lived there. There's nothing in the record indicating she doesn't live there. And it's like, but you didn't provide attestation 4, 5, or 6. We already have 2. We have evidence from both sides. I mean, there's no dispute in the record that she lived there. It isn't proved up great. You're all right about that. That's right. But there's also no evidence on the other side. So I'm not sure why we're interrogating that quite so hard to give people the ability to misdirect mailings when they think you live there and they're going to mail it to a horse stable but not your home. That is not Rule 55. That's not the Rule 55 I've worked on and know. That's not fundamental fairness.
Would you be making the same argument if Rule 55 required hand service of the copy of the application for default?
You know,
or is this about the expense of a stamp?
The expense of the stamp shows the complete unreasonability of the position on the other side of this, from my point of view, is why I keep hitting that. I mean, they spend $100 to send a process server there, and we say, do they have to keep going there? Judge McCurdy's question, do they have to keep going there? They have to put a 50-cent stamp on something, and Rule 55 puts the burden on them. I mean, it was written this way. Our Supreme Court wrote Rule 55, and it cares about what they know. Other states don't have this rule. Arizona and one other state has a rule like this out of 50 states that cares about their knowledge. They make you go find the lawyer. If they knew she had a lawyer, even if it was outside the record, they have to go find that lawyer. We're unique like this. Well, I don't know why we are. We seem to care a lot about not taking people's stuff away. I think that's why we're unique like this. So I'm not going to look behind that. But if it was hand service, if it's whereabouts, I just say the rule directs me to the words, and the words are the whereabouts. And that is, according to this court in Ruiz, the only published case where they can be found. The only evidence, although again, it's not pretty. You are right. This is not pretty evidence. There's a modest amount of evidence she lives there. There's literally no evidence she doesn't live there. There's none. So that's Rule 55. On that record, is it fundamental fairness to take away the house when for 50 cents we could have avoided the whole mess?
Switching gears just a bit, I was curious on your thoughts on the standard of review here, because there are cases that say on a decision whether to set aside a default judgment, we review for abuse of discretion. There are other cases that say when someone moves to set aside a judgment under 60B4 because the judgment is void, the standard of review is de novo. That makes sense to me where we're talking about whether there was personal or subject matter jurisdiction, but when we're talking about the known whereabouts of someone, so knowledge and the location where someone was on a particular date, those seem like intensive fact inquiries that we should defer to the trial court on. So I just wanted your thoughts on that.
First, I'd go with the black letter law that says under, Part 4, it is de novo, but second of all, it's still an abuse of discretion defined by legal error because this court does not quote the operative language from Ruiz. It didn't make the inquiry. It says proper notice was given, but it doesn't invoke Ruiz's rubric of the best notice practicable under the circumstances. That's a legal error. You've got to follow this court's indication on that. That's the only case about it.
Wait a minute. We presume that the superior courts know and follow the law. So why we're going to reverse because he didn't or she didn't specifically state that legal standard?
No, Judge McCurdy, I don't mean it like a Simon says. I mean, he both didn't do the work and he doesn't show the rubric. I mean, if he doesn't
Was it a
show.
requirement that he make some type of factual determinations at that point in time, or can he just say, I think that was proper, it was proper?
If you were left with the sort of unfortunate handiwork of a one-sentence order, you could presume all of that. You have a long paragraph on page 2 to page 3 of the ruling, App 4 to App 5, and it basically says, well, she was at a horse. It goes through a bunch of stuff that doesn't amount to best practical in the circumstances. So you can see his work. He showed his thought process not to be the rubric, and he didn't quote it. He didn't apply it, which gets you back to de novo. If I could reserve the remaining 6, I'd like, and also I don't know what that is. It was never served on me or provided to me, so I would object to its use.
All right, we'll wait until somebody offers it, or...
Sure, I'm not.
Yeah, all right.
Thank you, Your Honors.
Thank you. Mr. Hendricks?
Yes, may it please the Court, Jackson Hendricks and John Lohr on behalf of the appellee. I think I'll begin with sort of a word that was used by counsel that this does not require perfection, and we agree. It's not perfection. They're demanding perfection to be followed here under Rule 55, that every possible suspected address receive some sort of a mailing. But that's not how our standards of review guide the interpretation of our court rules. Service of process is always best practical under the circumstances, and that's especially true whereas here the defendant had actual notice of the complaint. She was personally served. I think that there are 3 points that in brief that I would like to make, that by mailing a copy of the application to the Two Hat Stables where she was personally served and Ash Street, which is in fact her primary residence and mailing address, that Rule 55 was in fact satisfied.
How do you know, counsel, what evidence shows it was her primary residence?
So according to the Maricopa County Assessor and Treasurer, and if I would offer into evidence, this is an exhibit that is from the...
Is this in the record?
Yes,
is this
Your Honor,
exhibit?
this is in the record. Yes, this
Okay,
is in the
can
record.
you tell us the exhibit number? Because we don't accept exhibits, but if you're referring to an exhibit that's in the record, we'll certainly consider what you have to point out on it.
I will have to look for this specific app.
Okay, well, maybe co-counsel can give you a sticky note or something before we start discussing it.
That would be great. I'd appreciate that. So this is at APP 047 and 048. That is the appellant's appendix that we're citing to there.
Okay.
And again, according to the county assessor and treasurer, we've highlighted there, the Ash Street residence is in fact listed as her primary address, but more importantly, it's the only mailing address. People that own property have the opportunity to include a separate mailing address, and so if she wanted Jackson Avenue listed as an alternative mailing address, she certainly had the opportunity to do that. But right there, you can see it's just Ash Street that's listed, and so that's why Ash Street matters so much. And I want to highlight that this is, in fact, property does matter. This is a real property tax lien foreclosure action, the subject of which is Ash Street. And so all of the mailing is really directed at Ash Street. The notices that counsel referred to earlier, some of the letters that were sent, those were sent required by Title 42-18202, where prior to filing any lawsuit, you have to mail copies of your intent to file a lawsuit to that address listed on the Maricopa County Assessor and Treasurer. So that's why all the mail was directed there. Everything ties into Ash Street. I want to point out...
Your client knew, though, that Ms. Searle lived in Tucson. I mean, her social media accounts indicated that she routinely worked at the stables where you did send the letter. So what's your response to that?
Yes, I have a couple of responses. I think the first is, we may have known that she went to the stables, but there was no affirmative knowledge where her residence was, or where she would receive mail other than that stables that was confirmed on the fact that she was served there the first time. And that Jackson Avenue property, I think to get into the question that you had raised a little bit, Judge Catlett, about what the standard of review is, well, that is a factual question. What knowledge is always a question of fact. And Rule 55 says if the whereabouts are known, then a mailing is required. And so you can't conclude just by the attempted and failed service at Jackson Avenue that she lives there. And the fact that was not brought up, I think, just to correct the record, is in that prior litigation, that prior action, service was attempted at Jackson Avenue. but then it was in fact affected at Ash Street through Rule 4.1b by serving her son as a co-residence there. Service was never challenged in that prior case. There was a resulting money judgment that was instead satisfied.
Would it have been sufficient for you just to mail to the stables?
I believe under the holding of Ruiz v. Lopez, that is all that's required. I think that you just need to mail a copy of the application to a known whereabouts, though I think in this case, because service was also completed at Ash Street, and there was so much correspondence and communication between the parties at Ash Street, that Ash Street, the trial court correctly held that Ash Street was also her known whereabouts, and so we're not challenging whether or not Ash Street was her known whereabouts. Though if you look at the text of the rule, there is, I think, support for a conclusion that only one address needs to be mailed. If you look at Rule 55A1, it gives you a laundry list of things that need to be included on the application for default. Among those is a mailing address, implying that one will suffice. Though in this case, we satisfied that rule above and beyond. We mailed to the Two Hat Stables, but also Ash Street. Again, it may have been out of an abundance of caution, though I will advise the court that it was our interpretation at that time that Ruiz v. Lopez actually requires a copy of the application be default to be mailed to the place of service, because that is a place where the defendant could be found.
I'd like to go back to the standard review for a minute on abusive. We talk about these things all the time and these concepts, and they're important. But here, was there evidence taken in this case? Sworn testimony?
There was no evidence taken.
So we're looking at the same exact facts as the Superior Court. Is that correct?
Correct, Your Honor. You are looking at the same facts.
So what deference do we owe to the Superior Court?
Well, I think that the reason that deference is required here is because the establishment of knowledge is based on an inference drawn by the sole time that Jackson Avenue appears in the record, which is the attempted but failed service. Defendant's case really relies on an inferential leap, that because you tried service there, that means you knew that she lived there.
But I'm going back to the standard review. Don't we, the three of us, get to draw our own inference from these facts?
I'm not sure if that standard is respectfully correct, Your Honor. My understanding is that the facts need to be viewed in the light most favorable to preserving the judgment. And under that standard, I think that...
I thought that we courts take a narrow view of default judgments in particular. Our Supreme Court has said, all cases, it's preferred that all cases be heard on the merits.
I don't disagree with that principle, that cases be decided on their merits, but there are competing goals as well, and that's the preservation of the finality of judgments. And I think under these circumstances that the trial court is empowered to make determinations of fact based on those available facts on the record, and that on appeal those facts are provided deference.
So appellant it's your view that appellant clearly had the burden of proof here in the Superior Court to prove that Rule 55 was not complied with?
Yes, Your Honor. I do believe that it was, I think all the cases, even under motions to set aside for excusable neglect or extraordinary circumstances like Rule 60b-6, the burden of persuasion still falls to the defendant. I think that I would go a step further and cite to cases like Duckstein v. Wolf and Barlage v. Valentine that require, in fact, a heightened standard of production, clear and convincing evidence when you are challenging service of process or impeaching service of process. And I think that's analogous here, since the challenge really is you knew, I think at its crux they're saying Arapaho knew that Searle lived at the Jackson Avenue property and yet failed for one reason or another to send it there. I don't think that's any really distinguishable from Barlage v. Valentine that had a clear and convincing review standard. And in that case, the last known whereabouts were upheld. The judgment was upheld on the grounds that the defendant did not produce enough evidence to show that the out-of-state mailing rule under Rule 4.2 was violated.
Your papers say de novo review, which kind of surprised me as the appellee. So I guess now you're saying that at the very least the trial court's findings as to knowledge and whereabout is instead subject to abuse of discretion?
I would not phrase it as abuse of discretion. I would just phrase it as it is a mixed question of fact and law, and that
If it's a mixed question of fact and law, it's de novo review.
we agree. I believe that the case law requires that it's a de novo review. But again, just to
Well,
reiterate.
then that goes to what Judge Brown was just asking you, that then we get to substitute our own judgment for what the evidence shows in the record.
My reading of the case law, respectfully, is that factual determinations and conclusions are still reviewed for clear error. And if I could point to another case that we cited in our standard, that's the Bank of Mellon, New York v. Dodev. That was a case where personal jurisdiction was challenged, and the standard of review in that case was de novo, but the court made clear that the questions of fact and the findings of the trial court were still going to be afforded deference and reviewed for clear error. In this case, I believe that's really analogous here, and so the finding that there was no knowledge should be supported unless this court finds that there is not substantial evidence to uphold that ruling. And I think in this case, there really is substantial evidence to support the trial court's conclusion that the Jackson Avenue property was just not a known whereabouts. Again, it appears only one time in the record, and the center of gravity still brings us back to Ash Street because it is where she was served in the prior action. It is where all the correspondence went to. It is where she lists affirmatively as her primary residence and mailing address, and it's the very subject of this tax lien foreclosure action. And I want to point out that there was 2 lawsuits involved here. There was communication between the parties, and not once did the defendant ever say, hey, by the way, you're sending me all these important letters, you're sending them all me these important papers, please send me mail to Jackson Avenue. Jackson Avenue disappears from the record after the failed service attempt, and everything else goes through Ash Street.
Speaking of Jackson Avenue, what in the, sticking strictly to the record, what was the purpose, if the record reveals, what was the purpose of sending the process server 5 times to Jackson Avenue?
Your Honor, there's not that question specifically, why 5 attempts were made, does not appear in the record. That was made, the defendants are making much of this now as proof that it was, in fact, clear and convincing evidence or evidence that there was knowledge was established. But we did not have a chance to rebut that below, and so I don't think it's properly before this court, since it wasn't before the trial court when making its determination to deny.
Why did that evidence make it into this record? Because it was from the other proceeding, correct?
That's correct, Your Honor.
So who was offering that evidence?
So we submitted the appellant. We offered that. We offered the certificate of service as proof that there was no knowledge, and that service was part of the record one way or the other, since it has to be filed just by the trial court rules. And so that did come in from the appellee. But what was told between, so they're making another claim that the process server, Mr. Hahn, received information that indicated that this was her home and that they went out 5 times as proof of knowledge. That was not litigated below.
Well, the word home is on the actual affidavit.
It is on the word home.
Yeah.
It is on the affidavit, but so is the word estate of Christine Searle. And so I don't know that you can draw much conclusions from that. From our perspective, that was just a form affidavit of non-serve that was provided by Mr. Hahn, not provided by Arapaho. And so at that time, Mr. Hahn, based on, if you just look at the 4 corners of that document, Mr. Hahn and Arapaho, as the person requesting the service, didn't even know if Ms. Searle was alive or dead, much less whether or not that was her home. And again, the fact that the service was tried there 5 times, that's just to satisfy due diligence, because very frequently in these tax lien foreclosure cases, the parties have to resort to service by publication or alternate service.
Do you agree that the best notice practicable, that's the standard in this case?
I don't disagree that that's the standard in this case, but that doesn't get to the entire text of the
Okay, and if that's the standard, how is it not practicable for your client to spend $1 to send a copy of a piece of paper to an address that your client also tried to serve 5 times, and it's listed on a document as being the home address, and that your client, I still think your client knew that Ms. Searle resided in Tucson based on its service at the stable. So how is it not practicable for your client to spend that small amount of money before taking equity in, in the amount of hundreds of thousands of dollars?
Well, Your Honor, the maxim that we require best notice practicable under the circumstances cannot be read to swallow the text of the rule, which still requires mailing only go to known addresses. And that requires some sort of a different standard. It is not, known cannot be expanded beyond known to suspected or things that might reveal actual notice. And another point I want to make, the defendants have not really offered any reason why mailing to Ash Street and the Two Hat Stables would have given better notice. We know that she received actual notice of the default judgment from a letter sent by the appellee to Ash Street. That's how she came to this case before. And if you look at her briefs below on the motion, the opening and reply on the motion to set aside, she repeatedly requests that all mailings go to Ash Street on the grounds that that would have given her best notice. And so under her own standard, she would have gotten notice had we sent mailing to Ash Street, which we did. And this is not up on appeal today in this particular matter, but the bulk of the litigation below was whether or not the mail actually went out to Ash Street. She demanded that it go to Ash Street, and we mailed it there. That's not on review anymore now. And so I think that because Ash Street was the sort of the center of gravity of the entire case, that mailing it there and Two Hat satisfied Rule 55A. And I would say that that's true even if this court disagrees with the findings of the lower court and finds that knowledge was established, that my client did know that the Jackson Avenue property was her known whereabouts. And again, I want to point out that the reason why, even though we disagree with that, as I just said, she never really explained why mail to Jackson Avenue would have given some additional benefit when she was getting notice at Ash Street. And I think that also we know that she was receiving mail at Ash Street. She never said send us mail anywhere else. She was personally served at Ash Street. And I want to reiterate that this is her primary residence and mailing address in a taxing foreclosure action. The property, in fact, does matter here. And so I think on that note here, I just want to reiterate that I don't believe that the trial court made any error, that my client complied with the spirit and the text of Rule 55A3 by mailing copies of the application for default to the place of service, the Two Hat Stables, but also to Ash Street, which is really the center of gravity in this case, the place where she was served in the prior action, where all the correspondence went, and I don't think that anything else was required and no error was made.
You've moved for attorney's fees under 12349, and I can tell you in 17 years as a practicing lawyer, I never once moved for fees under that particular statutory provision. So I'm wondering why you think that's appropriate here.
Well, Your Honor, I think that just based on the record below and the litigation below, that this was an unreasonable appeal. I think that the fact that we're quite confident that there was actual notice given to the defendant of the lawsuit, of the mailing for application for default, and that this particular tactic and this appeal does warrant fee shifting in this case.
Counsel, it just has to be much more than unreasonable. It has to be bad faith. There's two parts to that rule. You're alleging is Brian bad faith.
That's fair enough, Your Honor. I still think that just under the facts of this case and the history below, that fee shifting is appropriate under the circumstance. With that, I will yield my time.
Thank you.
All right, thank you, counsel. Mr. Jacob.
Well, Your Honors, he conceded de novo, and he conceded the standard of Ruiz, which concedes away the appeal. I mean, I don't see how their position survives those concessions at all. And I really would urge you to please look at page 26 of their brief. We're proving this out of their materials, not mine. They say, because you got to give rules a common sense reading, right? That's how we read Rule 55, not some crazy unreasonable way I propose, but commonsensically. Their page 26, the commonsensical read of known in Rule 55 is perceived, recognized, or understood. So that whole colloquy you had, Judge Catlett, about, so you knew she lived in Tucson, you sent somebody there for a couple of weeks. How could you not even minimally perceive their word, recognize their word, or understand that she could be found there? So of course, having conceded the standard of Ruiz, it can't possibly be the best practicable under the circumstances. And that is the appeal right there. That's the whole thing. They got up there at the start and said it was her primary residence. App 47 and 8 don't show that. They show that it was a mailing address in Maricopa County. I get it. That's part of the record too. But even under the wrong standard, even under the standard that they conceded doesn't apply, abuse of discretion, we should still win, because even though the proofs are poor, and we get it, your questions are all well taken, they aren't great proofs, the only proofs are that she lived there. I mean, she lived in Tucson, and she attested she lived there, and they sent somebody there over and over. So on an abuse of discretion standard, if that was, and
Well,
it's not.
Mr. Jacobs, it's pretty sloppy because she did not attest that she was living at that address during the time in question.
I agree it's sloppy. It's sloppy, and it's also the only evidence. It's like you want it to be 10 and it's 2, but it's 2 versus 0. And 2 versus 0 doesn't weigh very well for them. That is an abuse of discretion. They need someone to say she lived somewhere else when the whole theory of sending the process server is that she lived there.
But that's not even the argument you were making to the trial court. That's what confuses me.
Well, we made the argument to the trial court that if there's any doubt, you go with us. We made the argument to the trial court that, Jackson should have been the place of service, that they knew that she was at Jackson. So, I mean, we did make that argument. Has it changed in terms of the detail of our presentation? Absolutely. I believe that the argument just made concedes the appeal for the reasons I've already stated, and unless you have more questions, I have nothing further.
Michael? Do you have any more questions? No, sorry. All right, thank you.
Thank you all, Your Honor.
Thank you.
The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your briefing and your oral presentation. The court is now in recess.